Damages in case of death. Its concept. The fundamental principle of the law on damages is that one injured by a breach of contract or by a wrongful or negligent act or omission shall have fair and just compensation, commensurate with the loss sustained as a consequence of the defendant's act. Hence, actual pecuniary compensation is the general rule, whether the action is based on a contract or in tort, except where the circumstances warrant the allowance of other kinds of damages. In Julita Robles v. Court of Appeals, the Supreme Court ratiocinated why damages may be recovered, to wit, the law on damages is merely intended to repair the damage done by putting the plaintiff in the same position, as far as pecuniary compensation can do, that he would be had the damage not been inflicted and the wrong not committed. What may be recovered? When a death occurs due to a crime, the following may be recovered. 1. Civil indemnity ex delicto for the death of the victim. 2. Actual or compensatory damages. 3. Moral damages. 4. Exemplary damages. 5. Attorney's fees and expenses of litigation, and 6. Interest, in proper cases. Transport Corporation v. Luisito G. U. GR number 174161, February 18, 2015.
In the morning of December 1993, U, after having alighted from a passenger bus in front of Robinson's Galleria along the northbound lane of EDSA, was hit and run over by a bus driven by Gimena, who was then employed by petitioner R Transport Corporation. Loretta was immediately rushed to Medical City Hospital where she was pronounced dead on arrival. In February 1994, the husband of the deceased, respondent U, filed a complaint for damages before the RTC of Makati City against petitioner R Transport, Gimena, and MMTC for the death of his wife. MMTC denied its liability, reasoning that it is merely the registered owner of the bus involved in the incident, the actual owner being petitioner R Transport. It explained that under the bus installment purchase program of the government, MMTC merely purchased the subject bus, among several others, for resale to petitioner R Transport, which will, in turn, operate the same within Metro Manila. Since it was not actually operating the bus which killed the respondent's wife, nor was it the employer of the driver thereof, MMTC alleged that the complaint against it should be dismissed. For its part, petitioner R Transport alleged that respondent had no cause of action against it, for it had exercised due diligence in the selection and supervision of its employees and drivers and that its buses are in good condition. Meanwhile, the driver Gimena was declared in default for his failure to file an answer to the complaint.
The issue in the case is whether Gimena and the petitioner are liable. The court ruled, yes. Both the trial and appellate courts found driver Gimena negligent in hitting and running over the victim and ruled that his negligence was the proximate cause of her death. Negligence has been defined as the failure to observe for the protection of the interests of another person that degree of care, precaution, and vigilance which the circumstances justly demand, whereby such other person suffers injury. Verily, foreseeability is the fundamental test of negligence. It is the omission to do something which a reasonable man, guided by those considerations which ordinarily regulate the conduct of human affairs, would do, or the doing of something which a prudent and reasonable man would not do. Spouses ONG vs Metropolitan Water District. GR No. L 7664, August 29, 1958. Defendant owns and operates 3 recreational swimming pools at its Balara Filters, Diliman, Quezon City, to which people are invited and for which a nominal fee is charged. 14-year-old Domina Dorong drowned while swimming in one of those pools. Defendant admits the fact that plaintiff's son was drowned in one of its swimming pools but avers that his death was caused by his own negligence or by unavoidable accident. Defendant also avers that it had exercised due diligence in the selection of, and supervision over, its employees and that it had observed the diligence required by law under the circumstances. After trial, the lower court found that the action of plaintiffs is untenable and dismissed the complaint without pronouncement as to costs. Plaintiffs took the case on appeal directly to this court because the amount involved exceeds the sum of P50,000. The issue of the case is whether the death of minor Domina Dorong can be attributed to the negligence of defendant and or its employees so as to entitle plaintiffs to recover damages. The court ruled, decision is affirmed. The present action is governed by Article 2176 in relation to Article 2080 of the new Civil Code. The first article provides that whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damages done. Such fault or negligence is called quasi-delict. Under the second article, this obligation is demandable not only for one's own acts or omissions but also for those of persons for whom one is responsible. Since the present action is one for damages founded on culpable negligence, the principle to be observed is that the person claiming damages has the burden of proving that the damage is caused by the fault or negligence of the person from whom the damage is claimed, or of one of his employees. Burnell v. House. 54 Phil 327, January 30, 1930. Fortunata in verso with her daughter, Purificación Burnell went to Tacloban, Leyte to attend the procession on Holy Friday. After the procession, accompanied by two other persons, they passed along a public street. Purificación was allowed to get a short distance in advance of her mother and her friends. While in front of the offices of the Tacloban Electric Camp, Ice Plant, Ltd., an automobile appeared which frightened the child. She turned to run, but fell into the street gutter. At that time there was hot water running in the gutter coming from the electric ice plant of JV House. When the mother and her companions reached the child, they found her face downward in the hot water. The girl was taken to the provincial hospital. Despite his efforts, the child died that same night. It was certified that the cause of death was burns, 3rd degree, whole body, and that the contributory causes were congestion of the brain and viscera of the chest and abdomen. The defense was that the hot water was permitted to flow down the side of the street with the knowledge and consent of the authorities and that the cause of death was other than the hot water, and that in the death the plaintiffs contributed by their own fault and negligence. The trial judge dismissed the action because of the contributory negligence of the plaintiffs. The issue of the case is whether the action should be dismissed due to the contributory negligence of the plaintiffs. The court ruled, no. The death of the child was the result of fault and negligence in permitting hot water to flow through the public streets, endangering the lives of passers-by who were unfortunate enough to fall into it. The mother and her child had a perfect right to be on the street on the evening when the religious procession was held. There was nothing abnormal in allowing the child to run along a few paces in advance of the mother. No one could foresee the coincidence of an automobile appearing and of a frightened child running and falling into a ditch filled with hot water. The contributory negligence of the child and her mother, if any, does result not operate as a bar to recovery, but in its strictest sense could only in reduction of the damages. Astudillo v. Manila Electric. 55 Phil. 427. The district of Intramuros, Manila, is surrounded by a wall with openings at intervals for ingress or egress. One of these openings toward Manila Bay is known as the Santa Lucia Gate. Above the gate and between the wall and the street is a considerable space sodded with grass, with the portion directly over the gate paved with stone. This has become a public place where persons come to stroll, to rest, and enjoy themselves. Near this place is an electric light pole with the corresponding wires. The pole was located close enough to the public place above described that a person by reaching his arm out of the full length would be able to hold of one of the wires. At about 6 o'clock in the evening of August 14, 1923, a group of boys came to this place. One of these boys, for some unknown reason, placing one foot on a projection, reached out and grasped a charged electric wire. Death resulted almost instantly. This action was instituted by the mother of the deceased boy to recover damages from the electric company. The issue of the case is whether Manila Electric Company was at fault and negligence and is liable for the death of a studio. The court ruled, it is well established that the liability of electric light companies for damages for personal injuries is governed by the rules of negligence. Such companies are, however, not insurers of the safety of the public. We cannot agree with the defense of the Manila Electric Company in the lower court to the effect that the death of Juan Diaz Astudio was due exclusively to his negligence. He only did the natural thing to be expected of one not familiar with the danger arising from touching an electric wire, and was wholly unconscious of his peril. Had not the wire caused the death of this young man, it would undoubtedly be only a question of time when someone else, like a playful boy, would have been induced to take hold of the wire, with fatal results. The cause of the injury was one which could have been foreseen and guarded against. The negligence came from the act of the Manila Electric Company in so placing its pole and wires as to be within proximity to a place frequented by many people, with the possibility ever present of one of them losing his life by coming in contact with a highly charged and defectively insulated wire. Abruger vs. Cosmos Bottling Company and Intergames Incorporated. GR number 164749, March 15, 2017. The issue of the case is whether the defendants were negligent. The court ruled only Intergames was negligent. The sponsorship of Cosmos was limited to financing the race. Negligence is the failure to observe that degree of care, precaution, and vigilance which the circumstances justly demand, whereby another person suffers injury. The safety and precautionary measures undertaken by Intergames were short of the diligence demanded by the circumstances of persons, time and place under consideration. Hence, Intergames as the organizer was guilty of negligence. In staging the event, Intergames had no employees of its own to man the race, and relied only on the cooperating agencies and volunteers who had worked with it in previous races. It held no briefings of any kind on the actual duties to be performed by each group of volunteers. It did not instruct the volunteers on how to minimize, if not avert, the risks of the race. Since the marathon would be run alongside moving vehicular traffic, at the very least, Intergames ought to have seen to the constant and closer coordination among the personnel manning the route to prevent the foreseen risk. (1992) Quasi-delict. As the result of a collision between a public service passenger bus and a cargo truck owned by D, X sustained physical injuries and Y died. Both X and Y were passengers of the bus. Both drivers were at fault, and so X and C, the only heir and legitimate child of the deceased Y, sued the owners of both vehicles. A. May the owner of the bus raise the defense of having exercised the diligence of a good father of a family? B. May D raise the same defense? C. May X claim moral damages from both defendants? D. May Z claim moral damages from both defendants? Give reasons for all your answers. Suggested answer. A. No. The owner of the bus cannot raise the defense because the carrier's liability is based on breach of contract. B. Yes. D can raise the defense because his liability is based on a quasi-delict. C. Because X suffered physical injuries, X can claim moral damages against D, but as against the owner of the bus. X can claim moral damages only if X proves reckless negligence of the carrier amounting to fraud. D. Z can claim moral damages against both defendants because the rules on damages arising from death due to a quasi-delict are also applicable to death of a passenger caused by breach of contract by a common carrier, Arts. 1755, 1756, 1764, 2206, and 2219, Civil Code. Otto was the registered owner of a passenger jeepney, which was involved in a collision accident with a vegetable truck, resulting in the death of 4 passengers and injuries to 3. At the time of the accident, Otto was legally married to Maria but was cohabiting with Dania in a relationship akin to that of husband and wife. Could the heirs of the dead passengers and the injured persons recover damages from A. Otto, B. Maria, C. Dania? Explain each case. Suggested answer. A. Otto, yes. Insofar as the dead passengers are concerned, the heirs can recover damages on the basis of culpa contractual. If the injured persons are also passengers, Otto is likewise liable on the same basis of culpa contractual. However, if the injured persons are not passengers, then the liability for damages of Otto will be on the basis of a quasi-delict B. Maria, in view of the ruling in Jueniza v. Jose, 89 SCRA 306, that the passenger jeepney acquired by the husband during an illicit cohabitation with the paramour is conjugal property. Maria is liable to the same extent as Otto insofar as the conjugal property in the marriage between Otto and Maria could be answerable. But as regards her paraphernalia property, Maria cannot be held answerable. See Tanya, no. In Jueniza v. Jose, the paramour of the owner of the passenger jeepney that figured in an accident was held to be not a co-owner, and therefore not liable for damages. Article 144 is inapplicable.
The Ex-Electric Cooperative Service is a small town where the roads are lined with lush acacia trees. Normally these trees are pruned before the onset of the rainy season by the cooperative itself since the power lines of the cooperative are not infrequently affected by falling branches. This year, for financial reasons, the electric cooperative omitted the pruning in spite of reminders from the townspeople. In August this year, a strong typhoon hit the town and live wires fell to the ground. While the cooperative made a preliminary survey of the damages, it did not immediately take precautionary measures against possible harm. Thus, the attention of one of its employees was called to the falling wire in the center of the town. Before the cooperative could make the necessary repairs, a 4-year-old boy crossed the street and was electrocuted by the live wire. His parents sued the electric cooperative for damages. If you were counsel for the parents, what arguments would you advance to support your claim for damages and how much damages would you demand? If you were counsel for the electric cooperative, what defenses would you offer? If you were a judge, how would you decide the case? The damages that can be claimed by the parents are the following: civil indemnity for death, P30,000.00, actual and compensatory damages, moral damages for mental anguish, exemplary or corrective damages. As counsel for the electric cooperative, I would offer the defense of fortuitous event, because the strong typhoon could not be foreseen and even if foreseen, could not be avoided. As a judge, I would rule for the parents. The attention of the cooperative through its employee was called to the fallen live wire. If there had been care and diligence, the death could have been avoided. The cooperative could have made the necessary repairs before the 14-year-old boy crossed the street and was electrocuted by the live wire. It failed to do so, hence it is liable.
If a pregnant woman passenger of a bus were to suffer an abortion following a vehicular accident due to the gross negligence of the bus driver, may she and her husband claim damages from the bus company for the death of their unborn child? Explain. No, the spouses cannot recover actual damages in the form of indemnity for the loss of life of the unborn child. This is because the unborn child is not yet considered a person and the law allows indemnity only for the loss of life of a person. The mother, however, may recover damages for the bodily injury she suffered from the loss of the fetus, which is considered part of her internal organ. The parents may also recover damages for injuries that are inflicted directly upon them, for example, moral damages for mental anguish that attended the loss of the unborn child. Since there is gross negligence, exemplary damages can also be recovered. Rommel's private car, while being driven by the regular family driver, Amato, hits a pedestrian causing the latter's death. Rommel is not in the car when the incident happened. A. Is Rommel liable for damages to the heirs of the deceased? B. Would your answer be the same if Rommel was in the car at the time of the accident? Explain. 2%. A. Yes, Rommel may be held liable for damages if he fails to prove that he exercised the diligence of a good father of a family. Art. 2180, Par 5, and CC, in selecting and supervising his family driver. The owner is presumed liable unless he proves the defense of diligence. If the driver was performing his assigned task when the accident happened, Rommel shall be solidarily liable to the driver. In case the driver is convicted of reckless imprudence and cannot pay the civil liability, Rommel is subsidiarily liable for the damage awarded against the driver and the defense of diligence is not available. B. Yes, my answer would be the same.
Duty of the injured party. The injured party must observe due diligence of a good father of a family. It is the obligation of an injured party to observe due diligence of a good father of a family, particularly in cases of passengers of common carriers. Otherwise, the injured party will acquire the consequence of his contributory negligence. Contributory negligence is an act of the injured party contributing as a legal cause to the harm he has suffered, which falls below the standard with what is required to conform for the party's own protection. Article 2179 provides that when the plaintiff's own negligence was the immediate and proximate cause of his injury, he cannot recover damages, but if his negligence was only contributory, the immediate and proximate cause of the injury being the defendant's lack of due care, the plaintiff may recover damages, but the courts shall mitigate the damages to be awarded. A person shall be held as having contributed to his injury when he performed an act that brought about his injuries in disregard of warning or signs of an impending danger to health and body. To prove contributory negligence, it is still necessary to establish a causal link, although not proximate, between the negligence of the party and the succeeding injury. The injured party must choose the available causes of action for damages he will bring. The injured party must choose which of the available causes of action for damages he will bring. In the case of People of the Philippines versus Reyes Trucking Company, the aggrieved party in negligence cases has the choice to enforce civil liability arising from the crime under Article 100 of the Revised Penal Code, or enforce a separate action for quasi-delict under Article 2176 of the Civil Code of the Philippines. When the injured party chooses either of the aforementioned provisions, the injured party cannot avail himself of any remedy because he may not recover damages twice for the same negligent act or omission of the accused. Article 2177 provides that responsibility of the for fault or negligence under the preceding article is entirely separate and distinct from the civil liability arising from negligence under the Penal Code, but the plaintiff cannot recover damages twice for the same act or omission of the defendant. Injured party must show actual income. The damages for loss of earning capacity is in the nature of actual damages. The court cannot rely on the speculation on the amount of damages, but must depend upon competent proof and evidence on the exact amount that the party have suffered. Thus, as a rule, documentary evidence should be presented to substantiate the claim for damages for loss of earning capacity. However, damages for loss of earning capacity may be awarded despite the absence of documentary evidence when, number one, the deceased was self-employed and earning less than the minimum wage under current labor laws, in which case judicial notice may be taken of the fact that in the deceased's line of work, no documentary evidence is available, or number two, the deceased was employed as a daily worker earning less than the minimum wage under current labor laws. Cases: Manzarayans versus Moreta, GR number 12306. The facts of the case: Moreta, while driving his vehicle, ran over a minor named Bona. A case for recovery of damages was filed by the deceased's heirs. From the judgment rendered, an appeal was filed by Moreta. The issue: whether or not the defendant is liable for damages in favor of the deceased's heirs. Ruling: yes, the court ruled that the age of Bona was 8 to 9 years old at the time of the accident through the negligence of Moreta. It therefore follows that the defendant is liable for the damage in favor of the deceased's heirs and shall indemnify the plaintiff. Torion versus Aparra Jr., GR number 188493. The facts of the case: the respondent, who was the owner of a truck driven by his mechanic, fell off the dock and resulted to the death of Rodolfo and Mona Lisa Torion. Since the respondent allowed his mechanic to drive despite having only a student permit, the court ruled that both mechanic and owner are solidarily liable for damages on the heirs of the victim. However, the defendant appealed. The CA deleted the award of actual damages for loss of earning capacity of Rodolfo since there was no documentary evidence of his earning. Issue: whether or not the lack of documentary evidence of earning is fatal to a claim for a loss of earning capacity in case of death. Ruling: no. The court established that testimonies from competent witnesses who are familiar with the salary of the deceased are sufficient basis to determine the deceased's income before his death. People of the Philippines versus Pandasan Jr., GR number 194605. The defendant shot 3 people during a heated argument which resulted to the death of Tamano, Montegrico, and Paleg. The court rendered its decision and found the defendant guilty beyond reasonable doubt with payment of damages in favor of the deceased's heirs. The CA modified the award of damages. Issue: whether or not the damages awarded are proper. Ruling: yes. The court states that the value of death indemnity shall be according to the value of currency at the time the judgment is rendered. Bar questions and answers. 2009. Romel's private car, while being driven by the regular family driver Amado, hits a pedestrian, causing the latter's death. Romel is not in the car when the incident happened. A. Is Romel liable for the damages to the heirs of the deceased? Suggested answer: yes, Romel may be held liable for the damages if he fails to prove that he exercised the diligence of a good father of a family in selecting and supervising his family driver. The owner is presumed liable unless he proves the defense of diligence. If the driver was performing his assigned task when the accident happened, Romel shall be solidarily liable with the driver. In case the driver is convicted of reckless imprudence and cannot pay the civil liability, Romel is subsidiarily liable for the damages awarded against the driver and the defense of diligence is not available. Would your answer be the same if Romel was in the car at the time of the accident? Suggested answer: yes, my answer would be the same. Romel, who was in the car, shall be liable for damages if he could have prevented the misfortune by the use of due diligence in supervising his driver but failed to exercise it. 2010. On May 5, 1989, 16-year-old Rosano, who was issued a student permit, drove to school a car, a gift from his parents, on even date as his class was scheduled to go on a field trip. His teacher requested him to accommodate in his car 4 of his classmates because the van rented by the school was too crowded. On the way to the museum, which the students were scheduled to visit, Rosano made a wrong maneuver, causing a collision with a jeepney. One of his classmates died. He and 3 others were badly injured. A. Who is liable for the death of Rosano's classmate and the injured uh, suffered by Rosano and his three other classmates? At the time of the incident occurred in Rosano was still a minor. Being a minor, Article 218 of the Family Code applies. The school, its administrators, and teachers shall be liable for the acts of minor Rosano because of the special parental authority and responsibility that they exercise over him. The authority applies to all authorized activities, whether inside or outside the premises of the school, entity, or institution. The field trip on which occasion Rosano drove the car was an authorized activity and thus covered by this provision. Furthermore, the parent shall be of Rosano shall be subsidiarily liable pursuant to Article 219 and principally liable under Article 221 if they are negligent. How about the damage to the jeepney? With respect to the damages caused to the jeepney, only Rosano should be held liable because his negligence or tortious act was the sole proximate and immediate cause thereof. 2011, because of X's gross negligence, Y suffered injuries that resulted in the abortion of a fetus she carried. Y sued X for, among others, 1 million pesos for the death of a family member. Is Y entitled to indemnify the fetus she carried? Yes, since the fetus is already regarded as a child from conception. But the alternative answer is no, since birth determines personality. The accident did not result in the death of a person.
Good evening, Dean. Good evening, classmates. I'm going to report on the rules and crimes. The revised penal code provisions under these subjects are Article 100, which states that every person criminally liable for a crime or misdemeanor is also civilly liable. Additionally, Article 101 states that the exemption from criminal liability established in subdivisions 1, 2, 3, 5, and 6 of Article 12 and in subdivision 4 of Article 11 of this code does not include exemption from civil liability, which shall be enforced subject to the following rules. First, in cases of subdivisions 1, 2, and 3 of Article 12, the civil liability for acts committed by an imbecile or insane person and by a person under 9 years of age or by one over 9 but under 15 years of age who has acted without discernment shall devolve upon those having such person under their legal authority or control, unless it appears that there was no fault or negligence on their part. Should there be no person having such insane or imbecile or minor under his authority, legal guardianship, or control, or if such person be insolvent, said insane, imbecile, or minor shall respond with their own property, excepting property exempt from execution in accordance with the civil law. Second, in cases falling within subdivision 4 of Article 11, which states that any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it, the persons for whose benefit the harm has been prevented shall be civilly liable in proportion to the benefit which they may have received. The courts shall determine in sound discretion the proportionate amount for which each one shall be liable. When the respective shares cannot be equitably determined, even approximately, or when the liability also attaches to the government or to the majority of the inhabitants of the town, and in all events whenever the damage has been caused with the consent of the authorities or their agents, indemnification shall be made in the manner prescribed by special laws or regulations. Third, in cases falling within subdivisions 5 and 6 of Article 12, the persons using violence or causing the fears shall be primarily liable and secondarily, or if there be no such persons, those doing the act shall be liable, saving always to the latter that part of their property exempt from execution. The Civil Code provisions under these subjects are Article 2202, which states that in crimes and quasi-delicts, the defendant shall be liable for all damages which are the natural and probable consequences of the act or omissions complained of. It is not necessary that such damages have been foreseen or could have reasonably been foreseen by the defendant. Under Article 2204, in crimes, the damages to be adjudicated may be respectively increased or lessened according to the aggravating or mitigating circumstances. Under Article 2211, in crimes and quasi-delicts, interest as a part of the damages may, in a proper case, be adjudicated in the discretion of the court. Under Article 2230, in criminal offenses, exemplary damages as a part of the civil liability may be imposed when the crime was committed with one or more aggravating circumstances. Such damages are separate and distinct from fines and shall be paid to the offended party. Under delict, the source of its obligations is the act or omissions punished by law under Article 1157. The requisites for the actions are existence of the act or omission which caused the death or injury, and there must be a penal law defining and punishing such an act or omission. The quantum of proof needed is proof beyond reasonable doubt establishing the guilt of the accused. Now, who bears the burden of proof? It is the prosecution who must prove beyond reasonable doubt that the accused is guilty. What are the defenses available? Defense of a good father of a family in the selection and supervision of the employees is not a proper defense in this case. The employee's guilt is automatically the employer's civil guilt if the former is insolvent. So what are the sanctions and penalty? Either imprisonment, fine, or both, and payment of civil indemnities. Now, what are the difference between crimes and culpa aceliana? In crimes, there must be a penal law punishing the act, while in culpa aceliana, there can be quasi-delict as long as there is fault or negligence resulting in damage or injury to another. In crimes, there must be a criminal intent for criminal liability to exist, while in culpa aceliana, criminal intent is not necessary. In crimes, crime is a wrong against the state or the public interest. Quasi-delict is a wrongful act against a private individual. The guilt of the accused must be proved beyond reasonable doubt. The quantum of proof for quasi-delict is preponderance of evidence. The punishment in crimes is either imprisonment, fine, or both, while in culpa aceliana, the sanction is either reparation or indemnification of the injury or damage. What are the damages that may be recovered in crimes? 1. Actual or compensatory damages. Second, moral damages, which are the following: a criminal offense resulting in physical injuries, murder, homicide, rape. Note that in murder, homicide, rape, it is mandatory without need of proof, and the same rule also applies to frustrated murder. Additionally, robbery, adultery or concubinage, abduction, seduction or other lascivious acts, illegal or arbitrary detention or arrest, illegal search, libels, slander, or any other form of defamation. Exemplary damages may also be recovered. In People versus Tadula, the Supreme Court said the increase of the penalty or a shift to a graver felony underscores the exacerbation of the offense by the attendance of aggravating circumstances, whether ordinary or qualifying in its commission. Temperate damages may also be awarded in certain cases, such as the award of temperate damages is proper when no evidence of burial and funeral expenses is presented in the trial court. Cases. In the case of Mariano Mendoza versus Elvira Lim versus Spouses Gomez, the facts of this case states that an Isuzu elf truck owned by respondent Leonora Gomez and driven by Antenogenes Perez was hit by a Miami transportation bus registered under the name of Elvira Lim and driven by petitioner Mariano C. Mendoza. Owing to the incident, an information for reckless imprudence resulting in damage to property and multiple physical injuries was filed against Mendoza. Mendoza, however, eluded arrest. Thus, Spouses Gomez filed a separate complaint for damages against Mendoza and Lim, seeking actual damages, compensation for lost income, moral damages, exemplary damages, attorney's fees, and costs of the suit. For their part, Lim and Mendoza capitalized on the issue of ownership of the bus in question. Spouses Gomez argued that although the registered owner was Lim, the actual owner of the bus was SPO1 Cirilo Enriquez, who had the bus attached with Miami Transportation Company under the so-called Kabit system. Respondents then pleaded both Lim and Enriquez. The RTC found Mendoza liable for direct personal negligence under Article 2176 of the Civil Code, and it also found Lim vicariously liable under Article 2180 of the same code. As regards Lim, the RTC relied on the certificate of registration issued by the LTO in concluding that she is the registered owner of the bus in question. Although actually owned by Enriquez, following the established principle in transportation law, Lim as the registered owner is the one who can be held liable. The RTC awarded spouses Gomez actual moral exemplary as well as attorney's fees and the cost of the suit. Mendoza and Lim questioned the award of damages and the award of attorney's fees and appealed to the Court of Appeals. After evaluating the damages awarded by the RTC, it was affirmed by the CA with the exception of the award of unrealized income which the CA ordered deleted. Hence this petition. Issue: whether or not the award of actual moral and exemplary damages as well as attorney's fees and cost of suit was proper. Ruling: as to actual damages, Article 2202 of the Civil Code provides that in crimes and quasi-delicts, the defendant shall be liable for all damages which are the natural and probable consequences of the act or omission complained of. It is not necessary that such damages have been foreseen or could have reasonably been foreseen by the defendant. Article 2199 of the same code, however, sets the limitation that, except as provided by law or by stipulation, one is entitled to an adequate compensation only for such pecuniary loss suffered by him as he has duly proved. As such, to warrant an award of actual or compensatory damages, the claimant must prove that the damage sustained is the natural and probable consequence of the negligent act, and moreover, the claimant must adequately prove the amount of such damage. Although respondents allege in their complaint that the damage to their Isuzu truck caused them the loss of a daily income of 1,000 pesos, such claim was not duly substantiated by any evidence on record, and thus cannot be awarded in their favor. As to moral damages, they are awarded to enable the injured party to obtain means, diversions, or amusements that will serve to alleviate the moral suffering he has undergone by reason of the defendant's culpable action. In prayers for moral damages, however, recovery is more an exception rather than the rule. In fine, an award of moral damages calls for the presentation of evidence of besmirched reputation or physical, mental, or psychological suffering sustained by the claimant, a culpable act or omission factually established, proof that the wrongful act or omission of the defendant is the proximate cause of the damages sustained by the claimant, and the proof that the act is predicated on any of the instances expressed or envisioned by Article 2219 and Article 2220 of the Civil Code. A review of the complaint and a transcript of stenographic notes yields the pronouncement that spouses Gomez neither alleged nor offered any evidence of besmirched reputation or physical, mental, or psychological suffering incurred by them. Neither can respondents rely on Article 21 of the Civil Code as the RTC erroneously did. Article 21 deals with acts contra bonus mores and has the following elements. There is an act which is legal but which is contrary to moral, good, customs, public order, or public policy, and it is done with intent to injure. In the present case, it can hardly be said that Mendoza's negligent driving and violation of traffic laws are legal acts. Moreover, it was not proven that Mendoza intended to injure Perez. Thus, Article 21 finds no application to the case at bar. All in all, we find that the RTC and the CA erred in granting moral damages to spouses Gomez. As to exemplary damages, they may be imposed by way of example or correction only in addition among others to compensatory damages and cannot be recovered as a matter of right. In motor vehicle accident cases, exemplary damages may be awarded where the defendant's misconduct is so flagrant as to transcend simple negligence and be tantamount to positive or affirmative misconduct rather than passive or negative misconduct. Exemplary damages are in order given the fact that Mendoza was grossly negligent in driving the Miami bus. As to the award of attorney's fees, the award of attorney's fees being an exception rather than the general rule, it is necessary for the court to make findings of fact and law that would bring the case within the exception and justify the grant of such award. Thus, the reason for the award of attorney's fees must be stated in the text of the court's decision. Otherwise, if it is stated only in the dispositive portion of the decision, the same must be disallowed on appeal. In the case at bar, the RTC decision had nil discussion on the proper propriety of attorney's fees, and it merely awarded such in the dispositive. The CA decision, on the other hand, merely stated that the award of attorney's fees is merited as such is allowed when exemplary damages are awarded. However, the CA should have disallowed on appeal said award of attorney's fees as the RTC failed to substantiate said reward. As to cause of suit, the rules of court provide that generally, cause shall be allowed to the prevailing party as a matter of course. In the present case, the award of cause of suit to spouses Gomez as the prevailing party is in order. Interest by way of damages has been defined as interest allowed in actions for breach of contract or tort for unlawful detention of money already due. This type of interest is frequently called moratory interest. Interest as a part of damage is allowed not by application of arbitrary rules, but as a result of the justice of the individual case and as compensation to the injured party. The legal provision on the interest in quasi-delicts is Article 2211 of the Civil Code, which provides that in crimes and quasi-delicts, interest as part of the damage may in a proper case be adjudicated in the discretion of the court. Generally, interest is allowed as a matter of right for failure to pay liquidated claims when due. For in unliquidated claims, however, Article 2213 of the Civil Code provides that interest cannot be recovered upon unliquidated claims or damages except when the demand can be established with reasonable certainty. In the case at bar, although the award of exemplary damage is unliquidated, in the sense that Mendoza and Liv cannot know for sure before judgment the exact amount that they are required to pay to spouses Gomez, the award of actual or compensatory damages, however, such as the truck repairs and medical expenses, is arguably liquidated in that they can be measured against a reasonable certain standard. Moreover, justice would seem to require that delay in paying for past losses which can be reasonably made should be compensated through an award of interest. Cases. In the case of Agapito Fuellas versus Elpidio Candano, the facts of the case states that Pepito Candano and Rico Fuellas, son of Agapito Fuellas, were both 13 years old and classmates at St. Mary's High School, Dansalan City. While Pepito was studying his lessons in the classroom, Rico took the pencil of one Ernesto Cabanok and surreptitiously placed it inside the pocket of Pepito. When Ernesto asked Rico to return the pencil, it was Pepito who returned the same, an act which angered Rico, who held the neck of Pepito and pushed him to the floor. Villamira, a teacher, separated Rico and Pepito and told them to go home. Rico went ahead with Pepito following. When Pepito had just gone down to the schoolhouse, he was met by Rico, still in an angry mood. Angelito Aba, a classmate, told the two to shake hands. Pepito extended his hand to Rico, but the latter instead held the form by the neck and with his leg placed Pepito out of balance and pushed him to the ground. Pepito fell on his right side with his right arm under his body, whereupon Rico rode on his left side. While Rico was in such position, Pepito suddenly cried out, "My arm is broken." Rico then got up and went away. Pepito was helped by others to go home. That same evening, Pepito was brought to the Lanao General Hospital for treatment, and the results of the X-ray revealed that there was a complete fracture of the radius and ulna of the right forearm, which necessitated plaster casting. As a result, a civil case for damages was filed against Agapito Fuellas, father of the minor Rico. Issue: whether or not Agapito Fuellas may be held liable for damages for the deliberate criminal act of his minor son. Ruling: yes. Under Article 2180 of the Civil Code, the father, in case of his death or incapacity, the mother are responsible for the damages caused by the minor children who live in their company. Since children and wards do not yet have the capacity to govern themselves, the law imposes upon the parents and guardians the duty of exercising special vigilance over the acts of their children and wards in order that damages to third persons due to the ignorance, lack of foresight, or discernment of such children and wards may be avoided. If the parents and guardians fail to comply with this duty, they should suffer the consequences of their abandonment or negligence by repairing the damage caused. Bar question and answers. Number 1. As a result of a collision between taxi cab owned by A and another taxi cab owned by B, X, a passenger of the first taxi cab, was seriously injured. X later filed a criminal action against both drivers. May both taxi cab owner raise the defense of due diligence in the selection and supervision of their drivers to be absolved from criminal liability for damages to X? Answer: it depends. If the civil action is based on quasi-delict, the taxi cab owners may raise the defense of diligence of a good father of a family in the selection and supervision of the driver. If the action against them is based on culpa contractual or civil liability arising from a crime, they cannot raise the defense. Number two, as a result of a collision between the taxi cab owned by A and another taxi cab owned by B, X, a passenger of that first taxi cab, was seriously injured. X later filed a criminal action against both drivers. Is it necessary for X to reserve his right to institute a civil action for damages against both taxi cab owners before he can file a civil action for damages against them? Why? Suggested answer: no. Such reservation is not necessary. Under Section 1 of Rule 111 of the 2000 Rules of Criminal Procedure, what is deemed instituted with a criminal action is only the action to recover civil liability arising from the crime or ex delicto. All other civil actions under Articles 32, 33, 34, and 2176 of the new Civil Code are no longer deemed instituted and may be filed separately and prosecuted independently even without any reservation in the criminal action. The failure to make a reservation in the criminal action is not a waiver of the right to file a separate and independent civil action based on these provisions of the new Civil Code. Number three, a driver of a bus owned by Company Z ran over a boy who died instantly. A criminal case for reckless imprudence resulting in homicide was filed against the driver. He was convicted and was ordered to pay 2 million pesos in actual and moral damages to the parents of the boy, who was an honor student and had a bright future. Without even trying to find out if the driver had assets or means to pay for the award of damages, the parents of the boy filed a civil action against the bus company to make it directly liable for the damages. Question: will their action prosper? Number two, if the parents of the boy do not wish to file a separate civil action against the bus company, can they still make the bus company liable if the driver cannot pay the award for damages? If so, what is the nature of the employer's liability and how may civil damages be satisfied? Answer: number one, yes, their action will prosper. The liability of the employer in this case may be based on quasi-delict and is included within the coverage of independent civil actions. It is not necessary to enforce the civil liability based on culpa quiliana that the driver or employee be proven to be insolvent, since the liability of the employer for the quasi-delict committed by their employees is direct and primary, subject to the defense of due diligence on their part. Number two, yes, the parents of the boy can enforce the subsidiary liability of the employer in the criminal case against the driver. The conviction of the driver is a condition sine qua non. So that concludes my report. Thank you for listening and have a good evening. Thank you.
Good evening, classmates. Good evening, Dean. I will be reporting about the rules in quasi-delicts. Article 2214 states that in quasi-delicts, the contributory negligence of the plaintiff shall reduce the damages that he may recover. It must be noted that Article 2179 refers to doctrine of comparative negligence, while Doctrine 2214 refers to the doctrine of contributory negligence. The doctrine of comparative negligence also include the doctrine of contributory negligence. Under this provision, the parties both being negligent as the premise, if the negligence of the plaintiff was direct or proximate cause of the injury sustained by him, he cannot recover, and the action must be dismissed. If the direct or proximate cause of the injury sustained by the plaintiff was the defendant's fault or negligence, he can recover, but the liability of the defendant must be mitigated. Thus, it is understood that if the sole cause is the plaintiff's own fault, there can be no recovery. So let's talk about proximate cause. Proximate cause means the adequate and efficient cause which, in the natural order of events and under the particular circumstances surrounding the case, would naturally produce the event. Here are the examples. If a passenger boxes a driver who subsequently loses control of the vehicle, the act of the passenger is the proximate cause of the accident. Another one is that if somebody neglects to cover his ditch filled with hot water and a child carelessly falls in it, the negligence is the proximate cause, though the contributory negligence of the child would reduce the amount of recovery. So, what is the effect of contributory negligence of the plaintiff? Number one is that if this was a proximate cause of the accident, there can be no recovery. If the proximate cause was still the negligence of the defendant, the plaintiff can still recover damages, but the amount of the damages will be mitigated due to his contributory negligence. Thus, if he contributes the aggravation of the injury, damages in favor will be reduced. Examples of contributory negligence. So this is the case about Ginobiagan versus CA. The alleged contributory negligence of the victim, if any, does not exonerate the accused in criminal cases committed reckless imprudence, since one cannot allege the negligence of another to evade the effects of his own negligence. The facts are the case. An old lady was crossing a street at a Cebu market when two rigs 2 meters apart were approaching from a steep downgrade of the road. Joba, Jobagon's rig on one behind was going fast and was trying to overtake the one ahead. His rig bumped the old woman, who consequently fell on the road and died 3 hours later. He was asked why he bumped the old woman. He answered that it was the old woman that bumped him. The RTC and CA convicted him of homicide through reckless imprudence. Petitioner now contends that the reckless imprudence of the victim was the proximate cause of the accident that led to her death. Now, the issue is whether or not the doctrine of contributory negligence may apply in the criminal case. The answer is no. The alleged contributory negligence of the victim, if any, does not exonerate the accused. The defense of contributory negligence does not apply in criminal cases committed through reckless imprudence, since one cannot allege the negligence of another to evade the effects of his own negligence. Another rule in contributory negligence is that if the act of the injured contributed to the principal occurrence of the event causing the injury, he cannot recover. However, where in conjunction of the occurrence he contributes only to his injury, he may recover the amount that a defendant responsible for the event should pay for injury less a sum deemed a suitable equivalent for his own imprudence. Now, in the case of M.H. Rakes versus the Atlantic, uh, w- the facts of the case were as follows. One day, Rakes, together with his co-workers, was working in a company's yard, and they were transporting a heavy rails. There was no side guards installed on the sides of the cars, but the rails were secured by ropes. The track where the cars moved was weakened by a previous typhoon. It was alleged that the Atlantic's foreman was notified of the said damage in the tracks, but the same were left unrepaired. One day, while the cars were being moved and when it reached the depressed portion of the track, and while Rakes was beside one of the cars, the rope gave in and the rail slipped, thereby crushing his legs and causing it to be amputated. Rakes sued the Atlantic Gulf and he won. Now, the ruling is that whether or not the defendant is civilly liable. The ruling is yes. Rakes, as per evidence, could not have known of the damage in the track, as it was another employee he swore he notified who swore he notified the foreman about said damage. Further, his lack of caution in continuing to work is not of in nature as to constitute negligence on his part. On the other hand, though, Rake's contributory negligence can be inferred from the fact that he was on the side of the cars when in fact there were orders from the company barring words from standing near the side of the cars. His disobedience to this order does not bar his recovery of damages. Another ruling on contributory negligence is that in determining whether the passenger is guilty of contributory negligence, the age, sex, and his or her physical condition should be considered. Now, in the case of Kango versus Manila, on January 20, 1950, Jose Kango was riding the train of Manila Railroad where he was an employee. As the train drew near to his destination, he arose from his seat when he was about to alight from the train. Kango accidentally stepped on the sack of the watermelons, which he failed to notice because it was already 7 p.m. and it was dim when it happened. As a result, he slept and fell violently on the platform. His right arm was badly crushed and lacerated, which was eventually amputated. Cango sued Manila Railroad Company on the ground of negligence of its employees, placing the sack of melons upon the platform and in leaving them so placed as to be a menace to the security of passengers alighted from the company's trains. However, the CFI rules that Kangor failed to use the due caution in alighting from the train. So the issue is whether or not Kango is liable of contributory negligence. No, Kango was possessed of a vigor and agility of a young manhood, and it was by no means so risky for him to get off while the train was yet moving as the same act would have been in an age of feeble person. In determining the question of contributory negligence in performing such acts, that is to say, whether the passenger acted prudently or recklessly. The age, sex, physical conditions of the passengers are circumstances necessarily affecting the safety of the passenger and should be considered. What are the grounds of mitigation of damages for quasi delicts? That there must be the loss would have resulted in any event because of the negligence or the omission of another, and where such negligence or omission is the immediate and proximate cause of the damage or injury, and or the defendant has done his best to lessen the plaintiff's injury. Another related cases are is David Taylor versus the Manila Electric Railroad. The facts of the case is that plaintiff, a minor, a son of a mechanical engineer and having a considerable aptitude in training in mechanics, went out with a boy named Manuel, who is also a minor. They walked across an open space where the defendant company dumped in the cinders and ashes from its furnaces. Accordingly, the boys found some 20 or 30 brass fulminating caps scattered on the ground. They are intended for use in the explosion of blasting charges of dynamite, and having in themselves a considerable explosive. The boys took and played with them. Plaintiff held the cup while Manuel applied a lighted match to the contents. An explosion followed, causing more or less serious injury to all them. So the issue is whether or not defendant is liable for the injury sustained by the plaintiff. No, because it is quite clear the immediate cause of explosion, the accident which resulted in plaintiff's injury was in his own act in putting a match to the contents of the cup, and that having contributed to the principal occurrence as one of its determining factor he cannot recover. Related bar questions are in the 1988 it was asked that what are the requisites in order that the defendant can be held liable for damages in quasi-delicts? The answer would be in an action based on quasi-delicts, before the person injured can recover damages from the defendant, it is necessary that he must able to prove the following facts. Number one, that the fault or negligence of the defendant. the damages suffered or incurred by the plaintiff, and the relation of cause and effect between the fault or negligence of the defendant and the damage incurred by the plaintiff. Another question related is in the 1990 bar. So, Mr. and Mrs. R owned a burned out building, the firewall of which collapsed and destroyed the shop occupied by the family of Mr. and Mrs. S, which resulted in injuries to said couple and the death of their daughter. Mr. and Mrs. S had been warned by Mr. and Mrs. R to vacate the shop in view of its proximity to the weakened wall, but the former failed to do so. Now, Mr. and Mrs. S filed against Mr. and Mrs. R an action for recovery of damages. The former suffered as a result of the collapse of the firewall. In the defense, Mr. and Mrs. R relied on the doctrine of last clear chance, alleging that Mr. and Mrs. S had the last clear chance to avoid the accident if only they heeded the former's warning to vacate the shop, and therefore Mr. and Mrs. R's prior negligence should be disregarded. If you were the judge, how would you decide in this case? This case, state your reasons. So the suggested answer would be I would decide in favor of Mr. and Mrs. S. The propriety of building structure is responsible for the damages resulting from its total or partial collapse. If it is it if it should be done due to the lack of necessary repairs as provided in Article 2090 of the Civil Code. And third, as regards the defense of last clear chance, the same is not tenable because according to the Supreme Court in one case of DeRoy versus CA, the doctrine of last clear chance is not applicable to instances covered by the 2190 of the Civil Code. Furthermore, in Phoenix Construction versus IAC, the Court held that the role of the common law last clear chance doctrine in relation to Article 2179 of the Code is merely to mitigate damages within the context of contributory negligence. Lastly, the 2010 bar question states that on May 5, 1989, 16-year-old Rosano, who was issued a student permit, drove to school a car, a gift from his parents. On even date, as his class was scheduled to go on field trip, his teacher requested him to accommodate in his car, as he did. Four of his classmates because the van rented by the school was too crowded. On the way to a museum which the students were scheduled to visit, Rosanna made a wrong maneuver, causing a collision with a jeepney. One of his classmates died. He and the three others were badly injured. The question is who is liable for the damage to the jeepney? Explain. The suggested answer would be with respect to the damages caused to the jeepney, only Rosano would be held liable because his negligence or tortious act was the sole, proximate, and immediate cause. There.
In contracts and quasi-contracts. Good faith. So as to liability, all damages that are natural and probable consequences of breach, which pertains and which may have foreseen or could have reasonably foreseen. Article 2201 in the new Civil Code also provides that in contracts and quasi-contracts, the damages for which the obliger who acted in good faith is liable shall be those that are natural and probable consequences of the breach of the obligation, and which the parties have foreseen or could have reasonably foreseen at the time the obligation was constituted. The second would be fraud, bad faith, malice, and wanton attitude. As to liability, all damages which may reasonably attributed to non-performance. So, Article 2201 in the new Civil Code also provides that in case of fraud, bad faith, malice, or wanton attitude, the obliger shall be responsible for all the damages which may reasonably attributed to non-performance of the obligation. Next is equitable reduction by courts. In contracts, quasi-contracts, and quasi-delicts, the court may equitably mitigate the damages under the circumstances other than the case referred in the preceding article, as in the case of the following instances. First, that the plaintiff himself has contravened the terms of the contract. Second, that the plaintiff has derived some benefit as a result of the contract. Next, in case where exemplary damages are to be awarded, that the defendant acted upon the advice of the counsel. Fourth, that the loss would have resulted in any event. And lastly, that since the filing of the action, the defendant has done his best to lessen the plaintiff's loss or injury. Air France versus Carrascoso and CA, facts of the case. Air France, through its authorized agent, Philippine Airlines, issued to plaintiff a first-class round-trip airplane ticket from Manila to Rome. From Manila to Bangkok, plaintiff traveled in first class, but at Bangkok, the manager of the defendant airline forced the plaintiff to vacate the first-class seat that he was occupying because, according to the witness, there was a white man who the manager alleged had a better right to the seat. When asked to vacate his first-class seat, the plaintiff refused and told the defendant's manager that his seat would be taken over his dead body. A commotion ensued. According to the witness, many of the Filipino passengers got nervous in the tourist class. When they found out that Mr. Carrascoso was having a hot discussion with the manager, they came all across to Mr. Carrascoso and pacified him to give his seat to the white man, and the plaintiff reluctantly gave his first-class seat in the plane. Issue: was Carrascoso entitled to the first-class seat he claims and therefore entitles to damages? Ruling: yes. To authorize an award for moral damages, there must be an averment of fraud or bad faith. It is true that there was no specific mention of the term bad faith in the complaint, but the inference of bad faith is there. It may be drawn from the facts and circumstances set forth therein. The contract was averred to establish the relations between the parties. Passengers do not contract merely for transportation. They have a right to be treated by the carrier's employees with kindness, respect, courtesy, and due consideration. They are entitled to be protected against personal misconduct, injurious language, indignities, and abuses from such employees. So, it is that any rule or discourteous conduct on the part of the employees towards passenger gives the latter an action for damages against the carrier. Forrest versus Miranda, facts of the case. Respondent was one of the passengers of a jeepney driven by Eugenio Loga. While the vehicle was descending the Santa Mesa Bridge at an excessive speed, the driver lost control and the jeepney swerved to the bridge wall. Serious injuries were suffered by the defendant. The driver was charged with serious physical injuries through reckless imprudence, and upon interposing a plea of guilty was sentenced accordingly. Petitioners denied liability for breach of contract of carriage, contending that the day before the accident, the jeepney was sold to a certain Carmen Sacrament. Issue: to what damages is the respondent entitled? Ruling: the 10,000 actual damages awarded by the Court of First Instance of Manila were reduced by the Court of Appeals to only 2,000 on the ground that a review of the records fails to disclose a sufficient basis for the trial court's appraisal, since the only evidence presented on this point consisted of respondent's bare statement of his expenses and loss of income amounted to 20,000. On the other hand, The lower court said respondent did incur expenses. It is well known to further that the respondent was painter by profession and a professor of fine arts, so that the amount of 2,000 awarded cannot be said to be excessive. The attorney's fees in the sum of 3,000 also awarded to the respondent are as held on the ground that the court of first instance did not provide for the same, and since no appeal was interposed by the said respondent, it was allegedly error of the Court of Appeals to award them motu proprio. Petitioner fails to note that attorney's fees are included in the concept of actual damages under Civil Code and may be awarded whenever the court deems it is just and equitable. Anent the moral damages ordered to be paid to respondent, the same must be discarded. The court ruled that moral damages are not recoverable in damages action protected on a breach of contract of transportation. Where the injured passenger does not die, moral damages are not recoverable unless it is proved that the carrier was guilty of malice or bad faith. So let's go to bar questions and answer. So first situation. On March 5, 1992, Nonoy obtained a loan of 1 million from his friend Rafi. The promissory note did not stipulate any payment for interest. The note was due on January 5, 1993, but before this date, the two became political enemies. Nonoy, out of spite, deliberately defaulted in paying the note, thus forcing Rafi to sue him. Question number 1. What actual damages can Rafi recover? Number 2. Can Rafi ask for moral damages from Noynoy? So let's go to the suggested answers. For number 1, the answer is Rafi may recover the amount of the promissory note of 1 million together with interest at the legal rate from the date of judicial or extrajudicial demand. In addition, however, inasmuch as the debtor is in bad faith, he is liable for all damages which he may be reasonably attributed to the non-performance of the obligation. That is according to Article 2201 of the New Civil Code. For the number 2, yes, under the Article 2220 of the New Civil Code, moral damages are recoverable in case of breach of contract where the defendant acted fraudulently or in bad faith. So for the next question, Kiki sued LL for damages for breach of contract. At the trial, Kiki proved the breach of contract while LL proved that he acted in good faith. Give the law governing the damages which Kiki is entitled to recover. The second question is done. If Kiki proved that LL acted in bad faith, give the law governing the damages which Kiki is entitled to recover. These are the suggested answers. For number 1, if LL acted in bad faith, Kiki is entitled to recover from him as compensatory damages those consequences which are natural, probable, and which are the parties had foreseen at the time when obligation was constituted. For number 2, however, if LL acted in bad faith, Kiki is entitled to recover from him as compensatory damages those which may be reasonably attributed to non-performance of the obligation. Additionally, he may even be entitled to recover moral damages, exemplary damages, and attorney's fees.
Liquidated damages. What are liquidated damages? Liquidated damages fall under the provisions of Articles 2226 to Article 2228, found in Book 4, Title 18 of the Civil Code. Liquidated damages, as defined under Article 2226 of the Civil Code, as those agreed upon by the parties to a contract, to be paid in case of breach thereof. What this means is that the parties to a contract are allowed to stipulate on liquidated damages to be paid in case of breach. It is attached to an obligation in order to ensure performance and has a double function. First is to provide for liquidated damages. and second, to strengthen the coercive force of the obligation by the threat of greater responsibility in the event of breach. For reduction of liquidated damages, generally, when it comes to the reduction of liquidated damages, the court cannot change the amount of liquidated damages agreed upon by the parties. However, Article 2227 of the new Civil Code provides that liquidated damages, whether intended as an indemnity or a penalty, shall be equitably reduced if they are iniquitous or unconscionable. Such rule is also provided for under Article 1229 of the Civil Code of the Philippines, which states that the judge shall equitably reduce the penalty when the principal obligation has been partly or irregularly complied with by the debtor. Even if there has been no performance, the penalty may also be reduced by the court if it is iniquitous or unconscionable. So for rules governing breach of contract, under Article 1226 of the Civil Code of the Philippines, in obligations with a penal clause, the penalty shall substitute the indemnity for damages and the payment of interest in case of non-compliance, if there is no stipulation to the contrary. Nevertheless, damages shall be paid if the obliger refuses to pay the penalty or is guilty of fraud in the fulfillment of the obligation. The penalty may be enforced only when it is demandable in accordance with the provisions of this code. When breach not contemplated, Article 2228 of the new Civil Code provides that when the breach of the contract committed by the defendant is not the one contemplated by the parties in agreeing upon the liquidated damages, the law shall determine the measure of damages and not the stipulation. So an example case would be Urban Consolidated Construction Philippines versus Insular Life, GR number 180824, August 28, 2009. The facts of the case are, on October 13, 1989, respondent Insular engaged the services of Urban to construct a 60-story building within a period not to exceed 365 days at a contract price of 30,498,689 pesos. On February 19, 1991, the parties executed a general construction agreement which, among others, extended the deadline for the completion of the project to June 30, 1991, and increased the contract price to 38,885 pesos. The parties thereafter agreed to move the deadline to September 30, 1991, but the construction was beset by several delays. When Urban tendered the building for acceptance on July 21, 1992, Insular refused to accept the same. On February 11, 1993, Urban filed an action for collection of sum of money and damages against Insular, contending that Insular caused the delay in the completion of the project and that, as a consequence of said delay, Urban suffered damages. Insular allegedly failed to inform Urban about the government road widening project, which necessitated alterations or revisions in the plans and specifications and delayed the issuance of the building permit, as well as the boundary dispute which Insular had with the adjoining lot owner. Insular also allegedly incurred delay in the approval or payment of monthly billings, in the delivery of the materials to the construction site, and in the execution of a formal written construction agreement. So the issue in this case is whether Urban is liable to pay liquidated damages. As for the ruling, yes, the Court of Appeals therefore correctly held that the delay in the completion of the construction of the subject building cannot be attributed to Insular. Anent the award of liquidated damages, Article 2227 of the Civil Code provides that liquidated damages, whether intended as an indemnity or a penalty, shall be equitably reduced if they are iniquitous or unconscionable. In the case at bar, the liquidated damages computed on the basis of the GCA is 11,432,190 pesos. However, finding said amount to be unconscionable and citing Philinvest Land Incorporated versus Court of Appeals, the Appellate Court set the liquidated damages at 2,940,000. In Philinvest, the penalty for the delay in the completion of the project was 3,990,000 or 15,000 per day, but the court affirmed the reduction of said amount to 1,881,867 pesos and 66 centavos, considering that the project was already 94.53% complete and that Philinvest agreed to extend the period of completion, which extensions Philinvest included in the computing of the amount of the penalty. The court also noted that the contractor did not act in bad faith and that Philinvest was not free of blame, as it failed to pay the cost of work actually performed by the contractor. Thus, in herein case, the trial court ruled that the penalty charged for the delay, pegged at 15,000 per day of delay in the aggregate amount of 3,990,000, was excessive and accordingly reduced it. Considering the amount of work already performed and the fact that Philinvest consented to the 3 prior extensions, the Court of Appeals affirmed the ruling, but added as well that the penalty was unconscionable, as the construction was already not far from completion.
Good everyone. My topic is about compromise. So what is compromise? Article 2028 of the Civil states that a compromise is a contract whereby the parties, by making reciprocal concessions, avoid a litigation or put an end to one already commenced. So, according to the Code provision, the element of reciprocal concessions is the very heart and life of every compromise. And a compromise agreement is a contract. It is a contract between the parties, and which, if not contrary to law, morals, or public policy, is valid and enforceable between parties. Characteristics of a compromise. First is the consensual characteristic. So it is consensual because it requires mutual consent from both parties. And the next one is it is reciprocal because it is binding on each of two parties equally. It is nominate because it has a specific name given by law. It is onerous because it imposes an obligation. And it is accessory because in the sense that a prior conflict is presupposed, and once accepted, it is binding. Once accepted, it is binding on the parties provided there is no vitiated consent. And this is also true even if the compromise turns out to be unsatisfactory to either or both of the parties. Last one, it is the settlement of a controversy principally and is, but merely incidentally, the settlement of a claim. So it is principally a settlement of a controversy, and the settlement of a claim is merely incidental. So what are the kinds of compromise? First is there are two kinds, and first is the judicial compromise. So this kind of compromise is entered into to end a pending litigation. So there already exists a litigation in this scenario. So Judicial compromise, while binding between the parties upon its execution, is not executory until it is approved by the court and reduced to a judgment. So, in this case, a court approval is necessary. Whereas the second kind is done to prevent a litigation from arising. And it is treated as a contract and perfected by mutual consent. So there's this case of Merced versus Roman Catholic Archbishop. So the facts of the case are the leases of a parcel of land were occupying the premises for several years. One day, they were given notice to vacate, whereupon they went to court to have it fix the period of the lease and to have the lease's rights determined insofar as the improvements are concerned. A so-called compromise agreement was reached whereby the court was given discretion to fix the term, but the attorney who signed in behalf of the leases had not been so authorized. So the issue here is, does the agreement bind the leasee? The court held that yes, it is immaterial that the attorney was unauthorized, for what he signed in their behalf was not really a compromise. So there were no reciprocal concessions given, and what was agreed upon is merely what the law provides. Upon the other hand, a true compromise requires the grant of reciprocal concessions. So as mentioned earlier, that the essence of a compromise is the reciprocal concessions. So under Article 2029, the courts uh, has the duty to promote fair compromise. So the court shall endeavor to persuade the litigants in a civil case to agree upon some fair compromise. So the reason for this article provision is uh, it is to avoid litigation must, if possible, be avoided or minimized. Suspension of civil action or proceeding. So Article 2030, every civil action or proceeding shall be suspended. So there are two instances where a civil action or proceeding shall be suspended. First is if willingness to discuss a possible compromise is expressed by one or both parties. Second one, if it appears that one of the parties, before the commencement of the action or the proceeding, offered to discuss a possible compromise, but the other party refused the offer. So the duration and terms of the suspension of the civil action or proceeding in similar matters shall be governed by such provisions of the rules of court as the Court shall promulgate, as the Supreme Court shall promulgate. Said rules of court shall likewise provide for the appointment and duties of amicable compounders. So those are the two instances that shall suspend a civil action or proceeding. So the revised rules of court, as a matter of fact, even mentioned as one of the grounds to dismiss the fact that no attempt has been made to arrive at a compromise. So in cases where the law allows a compromise, the fact that an attempt to arrive at one has been made. So it mentioned that it mentioned that in cases where the law allows a compromise, because there are instances where compromise is not allowed, as I will discuss it later. So the fact that that an attempt to arrive at a compromise has been made, it should be stated in the complaint. Otherwise, the complaint can be dismissed. Of course, if no compromise is allowed by the law, the condition precedent does not apply. So postponements, well, postponements must be discouraged and still they can be allowed when the parties are trying to reach an amicable settlement. So that's an exception. Um, Offers to arbitrate not included. This provision does not include offers to arbitrate. It refers only to a compromise. So upon terms that the court can ascertain and determine if they are reasonable, a compromise could dispense with the trial, but an arbitration would merely prolong the case since the arbiter's decision would be subject or on appeal. So mitigation of damages. So the courts may mitigate the damages to be paid by the losing party who has who has shown a sincere desire for a compromise. So when parties has shown a sincere desire for compromise, the courts may mitigate damages. So when court approval is required, the court's approval is necessary in compromises entered into by guardians, parents, absentees, representatives, and administrators or executors of decedents' estates. So those are when the court's approval is necessary. So there are other rules. So first is an agent needs a special power to compromise. So an agent needs a special power of attorney. And the next one is if an attorney is not authorized by the client, he cannot compromise his client's claim unless the client fails to repudiate promptly the act after knowing of it, in which case the client will be in estoppel. So as a general rule, attorneys, an attorney is needs an authority from his client, and the exception is when client fails to repudiate, so because he will be in estoppel. Then last one is, well, under Article 225 of the Family Code, widow is the legal administratrix of the property pertaining to the children under the parental authority. Said article does not give her authority as legal administratrix to compromise their claims for indemnity arising from their father's death, for a compromise has always been deemed equivalent to an alienation, and is an act of strict ownership that goes beyond mere administration. So widow cannot compromise uh, for the claim of the children under parental authority. Juridical persons. Juridical persons may compromise only in the form and with the requisites which may be necessary to alienate the property. So the rules for a juridical person to enter into a compromise. A corporation may compromise through authority, but provided it is granted by the board of directors, and that the form and the requisites for alienation of property must be observed. Second is the municipal council can also compromise provided that the legal requirement for the alienation of property are complied with, and that provided further that the provincial governor approves the compromise. So there must observe the requirements and the approval of the provincial governor. So civil liability for an offense. So there may be a compromise upon the civil liability arising from an offense, but such compromise shall not extinguish the public action for the imposition of the legal penalty. So, according to this provision, generally, if a crime has been committed, there can be a compromise on the civil liability, but not generally on the criminal liability, because the social and public interest demands the punishment of the offender. So you cannot no compromise on criminal aspect. The only exception to this rule is that uh, in some crimes, there can be a sort of compromise in the cases of crimes against chastity and violations of the Internal Revenue Code. So, violations of the Internal Revenue Code are an exception. So, the criminal aspect can be the subject of a compromise. So in the case of the Sala versus CFI, the facts of the case are petitioner for the petitioner the Sala sued Sumangil for damages for the death of his son, who was a passenger of the jeepney being driven by private respondent Sumangil. The trial court dismissed the complaint on the ground that the obligation has been settled as shown by a sinumpaang salaysay executed by the Sala. So the issue is whether the sinumpaang salaysay is contrary to law, public order, public policy, morals, or good customs, or prejudicial to a third person with a right recognized by law. So the court held that no, if the act causing damage to another also constitutes a crime, the civil liability arising from the criminal act may also be validly waived. What is not allowed in this jurisdiction is to compromise or waive the criminal aspect of a case. In a compromise or a waiver of the civil aspect of the case, the restriction imposed by law is that it must be entered into before or during litigation, so never after final judgment. Compromise on the civil aspect of a case is valid even if it turns out to be unsatisfactory to either or both of the parties. So as mentioned earlier, there are instances when no compromise is allowed. So first is the civil status of person. So status of a persons and affiliation of children cannot be ordered, recorded in the civil registry in mere summary proceedings, and also it cannot be the subject of a compromise agreement. Second is the validity of a marriage or a legal separation. Yes, because as we all know, marriage is an inviolable institution, and thus it cannot be entered into by a mere compromise and is not allowed by and any ground for legal separation. Next is the future support. Future support cannot be entered into a compromise agreement. And the jurisdiction of courts as provided by law, jurisdiction of courts, the Supreme Court can um, can provide for the jurisdiction of courts and cannot be subject to an agreement. Next one is future legitim. So future legitim of heirs cannot be subject of a compromise agreement. So the recognition of an illegitimate child is not prohibited, and if a child has already been recognized and there is no dispute concerning his status, his share in the inheritance proceedings may be the subject of compromise. So the scope of a compromise comprises only those objects which are definitely stated therein or which by necessary implication from its terms should be deemed to have been included in the same. So those for compromise can deal with those objects definitely stated, and second, those included implicitly according to the terms stated. So that's the scope of compromise. The second, the second paragraph, a general renunciation of rights is understood to refer only to those that are connected with the dispute which was the subject of the compromise. So even if the renunciation is general, it is understood to refer only to rights connected with the dispute involved and not to other rights. A compromise must be strictly construed and can include only those expressly or impliedly included therein. Therefore, just because a lessee renounces possession does not mean that she waives her right of redemption granted by another agreement. Where a compromise agreement is onerous, the doubt should be always settled in favor of the greatest reciprocity of interest. So in the case of International Hotel Corporation versus Honorable Elias Asuncion, it held that a court cannot include in a compromise judgment terms which have not been agreed upon between the parties, except if the same are required by law or by the rules to be included or are necessary consequences of the stipulations. So effect of a compromise. A compromise has upon the parties the effect and authority of res judicata, but there shall be no execution except in compliance with a judicial compromise. So the res judicata as an effect of a compromise. So compromise being a contract has the effect of res judicata only if there has been no vitiated consent. So, and therefore, it is not exactly the same as the res judicata referred to in the law of procedure, but generally how the compromise binds the parties even without judicial approval. However, if there is no judicial approval, it can be enforced only by a court litigation, not by execution. Incidentally, a compromise or amicable settlement before a court of justice, even if reduced to writing, is not valid unless signed by the parties. General rule, judgment not appealable. Exception when there is a vitiated consent. Judgment on compromise is not appealable and may therefore be immediately executory unless a motion is filed to set aside the error on the ground of vitiated consent. So when judgment on compromise is void, a judgment based upon a compromise entered into by an attorney without specific authority from the client is null and void. Such judgment may be impugned and its execution restrained in any proceeding by the party against whom it is sought to be enforced. In the case of Cruz et al. Versus IAC, it is Hornbook knowledge that the judgment on compromise has the effect of res judicata on the parties and should not be disturbed except for vices of consent or forgery. To challenge the same, a party must move the trial court to set aside the said judgment and also to annul the compromise agreement itself before he can appeal from the judgment. Also in the case of Bobis versus Provincial Sheriff of Camarines Norte, if, if a writ of execution is issued to enforce a judgment based on a compromise, the writ cannot be enforced against a person, although a party to the case was not a party to the compromise agreement, and who in fact had been absolved from liability. a compromise in which there is mistake, fraud, violence, intimidation, undue influence, or falsity of documents is subject to the provisions of Article 1330 of this code. However, one of the parties cannot set up a mistake of fact as against the other if the latter, by virtue of the compromise, has withdrawn from a litigation already commenced. So effect of compromise when there is vitiated consent. Any of the vices of consent may cause the annulment of the compromise. So those referred to in this article may cause the annulment of the compromise. And second, the alleged vitiated consent must be. Third, mere inadequacy of cause is not equivalent to vitiated consent. And if a party consents to a compromise because of an erroneous report submitted to the court, his error is ground to set aside the compromise, even if the compromise was approved by the court. The last one is the presence of invalid stipulations in a compromise agreement does not render void the whole agreement where such invalid stipulations are independent of the rest of the terms of the agreement and can easily be separated therefrom without doing violence to the manifest intention of the parties. So Article 2039, when the parties compromise generally on all differences which they might have with each other, discovery of documents referring to one or more but not to all of the questions settled shall not itself be a cause for annulment or rescission of the compromise, unless said documents have been concealed by one of the parties. But the compromise may be annulled or rescinded if it refers only to one thing which one of the parties has no right as shown by the newly discovered documents. So the the effects of discovery of documents referring to matters compromised upon. So the first paragraph refers to a compromise on all differences. The second, a compromise on one thing. The effect of the discovery of the documents is set forth in this provision. So the reason for the first paragraph, it is a compromise on the whole and not on the specific things. So final judgment, if after a litigation has been decided by a final judgment, a compromise should be agreed upon, either or both parties being unaware of the existence of the final judgment, the compromise may be rescinded. Ignorance of a judgment which may be revoked or set aside is not a valid ground for attacking a compromise. A compromise, so according to this provision, a compromise in a case like this may be rescinded, and the ignorance of a judgment may have been on the part of one party or on the part of both parties. So the next provision talks about non-compliance of compromise. So if one of the parties fails or refuses to abide by the compromise, the other party may either enforce the compromise or regard it as rescinded and insist upon his original demand. So better understand that provision, we have this case of City of Zamboanga versus Mandi. So Zamboanga City wanted to expropriate the lot owned by Julian. The expropriation was intended to expand the Pasunangka Park. So the trial court gave the authority to take possession of the property. So of course, upon payment of the just compensation. So it was fixed at 0.18 per square meter. So the Court of Appeals affirmed judgment of the trial court. However, Julian filed a notice of appeal to the Supreme Court because uh, he is not satisfied of the price. But so Julian sent a letter to the YC mayor stating that pending appeal, they were accepting the offer of the city to buy the lot at 3 pesos per square meter. So the Sangguniang Banglungsod adopted a resolution on May 13, 1987, authorizing the OIC mayor to enter into a compromise agreement for the acquisition of the lot for 3 pesos per square meter, subject to the approval of the Supreme Court. The agreement was signed on the same date. The parties filed with the Supreme Court a motion to approve compromise agreement. So they filed the compromise agreement for the approval of the Supreme Court. So pending that motion, the Sangguniang Panglungsod authorized the OIC mayor to sign for and or on behalf of the city the deed of sale covering the acquisition by the city of the lot at 3 pesos per square meter. So the resolution did not impose any condition of prior approval by the Supreme Court. And so it was that pursuant to the authorization granted, the deed was signed by the parties and for 3 pesos per square meter. The city received Subsequently, the city received a copy of the entry judgment of the appellate court showing that it had become final and executory. So the judgment the judgment of the appellate court, in which the price of the land is at 0.18 per square meter, was finalized. It had become final and executory. So Julian instituted before the RTC a petition for mandamus, praying that the city be made to comply with the agreement, particularly, so Julian filed mandamus compelling the city to enforce the compromise agreement entered into by them. So they signed a deed of sale, which they bought the lot from Julian at 3 pesos per square meter. However, Zamboanga does not want to pay because the judgment from the appellate court has just come out. So the issue here, whether or not Julian can compel the city to comply with the compromise through a mandamus. So held, yes, the Supreme Court found the writ of mandamus properly issued. Ignorance of a judgment is not a valid ground for attacking a compromise. The course of action should have been an action for rescission, which has not been availed of here. Article 2040 of the Civil Code explicitly provided if after a litigation has been decided by a final judgment, a compromise should be agreed upon, either or both parties being unaware of the existence of the final judgment. The compromise may be rescinded. Ignorance of a judgment which may be revoked or set aside is not a valid ground for attacking a compromise. Julian was well within his right in seeking on the enforcement of the compromise through a petition for mandamus on the strength of Article 2041 of the Civil Code, providing that if one of the parties fails or refuses to abide by the compromise, the other party may either enforce the compromise or regard it as rescinded and insist upon his original demand. So that's the end of my report. Thank you.